I'll introduce them. One last announcement, if you need CLE credit, you can get 1 hour of CLE credit. Dale Goodman here is collecting the $5 for that should you seek the CLE credit. So please be sure to see her. Thank you all. All right, so let's begin. So John, to my right, John Brookhouse obtained his law degree from the University of Dayton in 2009. And began practicing consumer bankruptcy soon after in January 2010. He went out on his own, started his own practice in 2015, and remains focused on consumer bankruptcy and is able to assist clients with other legal issues as necessary. He is a member of several organizations, including the W. Homer Drake Jr. Georgia Bankruptcy American Inn of Court, American Bar Association, American Bankruptcy Institute, MACBAG, and he has also worked as a volunteer with the BAT program at Georgia State School of Law, advising students and representing clients. To his right, we have Julie Ananias, staff attorney for Nancy Whaley, where she has worked since 2012. She now handles matters before Judge Cavender, but has also appeared before Judge Hagma and Judge Mullen. She attended the University of Alabama at Birmingham for her undergraduate and received her JD from Liberty University School of Law. After that, she worked at Simrad Law Firm before moving over to the trustee's office. And to her right, we have Karen Visser, our resident expert from the court. She is currently law clerk to Judge Richard Craig. She is a graduate of Georgia State University College of Law. After graduating, she worked at King & Spalding for a year or two, and then went to clerk for Judge Drake from 2001 to 2012, and again from 2014 to 2016. She had a brief interlude at King & Spalding again at 2012 to 2014. She is the author of, co-author of Bankruptcy for General Practitioners, an editor and updater of Chapter 11 Reorganization, and a co-adjunct professor at Mercer University. I am excited to have our panelists speak to you on this topic. They have a lot of great information to get to, so I will pass it on to them to do so. Thank you, Cece.
So I'm very excited to be here today. I've never participated in a lunch and learn before, and we're going to talk about lien avoidance, and that's not the most exciting topic, but it is an important issue, and we hope that all of us through this discussion will come away with some important things that we didn't know and some practical tips that Julie and John would share with us about how it works in the real world. To that end, we're going to be discussing today what exactly are judicial liens and non-possessory, non-purchase money securities interests household goods, what they are not, how avoiding them is different than lien stripping, how the lien avoidance statute works, and some of the typical sticky situations that we come across, and they make us scratch our heads and say, what do we do with that? And we're going to talk about why you might decide to avoid a judicial lien or security interest in one case and maybe not bother in another. If we have time, we're going to go into everybody's favorite topic, service. But the information in the slide is really very dense about service. And if we don't cover everything that you think we should have covered in enough detail, the slides, as Cece mentioned, will be on the court's website available for you as reference tool. And we would also like to take a moment to plug the service monograph that Judge Massey wrote a very long time ago. It's still on the court's website, and it's been updated recently to account for changes in the new plan. So really, if you have really detailed questions about service, you might want to look there. I am glad to be joined by Julie and John today because they're going to give us some practical insight into this topic. We are going to pause along the way, as Cece said, a break in what we think are sort of two different topics to have some questions or comments. And then, of course, at the end, we'll have time for the general questions or things that we didn't get the chance to cover. made this fancy so the words wouldn't come up immediately. All right, so the starting point and a reminder for everyone is that the authority for lien avoidance comes from the Bankruptcy Code. Section 522F tells us that we can avoid the judicial liens and the non-purchase money. I'm just going to call them NPMSI for short. We also have a rule that governs how you do this procedurally, and our new General Order 21/2017 is our local authority that covers how we do this. So the basic premise here is that lien avoidance protects the individual debtor's right to exempt property. As you can imagine, if you have an exemption in property, it's pretty helpful for keeping that property away from a trustee who wants to sell it and take the money and pay unsecured creditors. It doesn't do this debtor very much good, though, if there's a lien on it, because the secured creditor can still take it and foreclose on it with relief from the state. So this ability to avoid the lien helps us give the debtor a meaningful exemption in property that otherwise is covered by these liens. Of course, Congress decided that only people who qualify for this lien type, judicial lien holders and holders of NPMSIs, can avoid the lien. Now, what does it mean to have an impaired exemption? It essentially means that after you account for all the other liens on the property and the debtor's exemption, there's no equity there for the judicial lien to attach to. And if there is a little bit of equity, then the lien is partially avoidable and not fully avoidable. All right, so a judicial lien avoidance or avoidance of an NPMSI is not stripping the lien. You can strip a lien in a Chapter 13 case, not in a Chapter 7 case. And you can avoid a lien in both Chapter 13 and Chapter 7 cases through 522F, but they are not the same thing. When you strip down or strip off a lien from property, you are using Section 506A to value the property. And you don't worry about whether the debtor has an exemption in it or any of that. When you are using 522F to avoid the judicial lien or NPMSI, you do need to figure out what the property is worth, but you're not using 506A to value and show that there is a claim that exceeds the value of the property. Julie or John, do you have anything to add? I know you see in your review of Chapter 13 plans some confusion sometimes over whether you're stripping a lien or avoiding a lien.
Yeah, this is not super common. Most people have gotten this under control, but there are still those occasions where people get confused whether they want to avoid the lien or if they're wanting to strip the lien, particularly with the new plan, and sometimes it's in both sections. Sometimes you get in 3.4 and 3.2. But just on a practical note, look at what it is, and I'm going to go through some additional common mistakes that we see a little bit later on in the presentation. But yeah, one of the things that I commonly see if this is confused is that it may be a second mortgage is put into this section to be avoided instead of stripped where it should be, which is what the real intention is. A lot of times you'll also see an objection from us, from at least our office, if we can't tell if it's a second mortgage on a property they no longer have and you really are wanting to avoid it. If we can't tell, you're probably going to get an objection. So just make sure that you are clear on whether you're wanting to avoid a judicial lien or if you're really trying to strip the lien and distinguish which section you want that to be in. So, and you'll avoid objections from, at least from me. John?
No, I think you guys are pretty clear on that. At this point, that's fairly well settled. I think just about everybody here understands the primary difference between the two. So.
All right. Maybe. Please.
Yeah. I'm trying to turn our camera on.
All right.
We need to keep the button.
I don't know why. Did you move the more chair?
Hi, everyone.
We did rehearse this once. And
Hey guys, how's it going?
We didn't do it.
so Jumbotron.
I think you moved the thingy. Oh, that's why, because you moved your laptop. Okay, here we go. Sorry. You moved the laptop. All right, so how do you do lien avoidance? If it's a Chapter 7 case, even after the new plan has come out and all of the confusion over that, you still do Chapter 7 lien avoidance in the same way you always did it. You file a motion, and it initiates a contested matter under Rule 9014, and that means that most of the adversary proceeding rules will apply. So if for some instance you had a really complicated case and you needed discovery, you could do that in the context of this contested matter. We do have a local rule 6008-1 that says you have to do a notice of requirement of response with your motion, and it basically tells the creditor they have 21 days to respond, and if they don't respond, the court may enter an order. So you filed your motion, you've attached your notice of requirement of response, and you filed a certificate of service indicating service, we'll talk about it later, in accordance with 7004. We also then, of course, if we don't have, generally the court will enter that order, a standard order just granting the motion. You might get your motion denied if someone has looked through and reviewed and the court determines that it wasn't properly served. And I don't know for sure if all the judges would do this, but in Noonan, for example, you might get an order saying that this schedule shows there's equity in the property and therefore, based on what's information in the record, we can't grant the motion even though it's unopposed. So the more pleading you give us, if there's some kind of extenuating circumstances to why it's still avoidable, or maybe you would just make sure before you file your motion that you've looked at the schedules and really the schedules show what you think are the facts and that it is in fact avoidable, will save you getting that order.
Just real quick on that, Karen, and I know a lot of our judges now have kind of moved over to the more comprehensive motion. I know we used to have a very simple motion where you just said the property is exempt. We've moved a little bit more towards listing all of the property. I think that's probably best practice for this anyway, for the point you're talking about there, where there may be something with a little equity. If you take the time to put in the motion, which several of the judges are requiring now, each item that you're claiming value and exemption on, then you're going to be doing a double check on yourself before you even file that motion and have to get that order denying. So just take the time to look at each item and make sure that you're not leaving something there, because it can be easy to overlook it, especially if you're using, programs, your best case or whatever. Just be careful to do your own analysis of that with the motion, and don't just plug in a very quick, lien avoidance motion and file it. Take the extra 5 minutes, check your numbers, and you don't have to worry about that problem.
And we'll also make a plug at this point, and again, because CC wants us to remind everyone that there's a lien avoidance calculator on the court's website, and you can use that lien avoidance calculator to run everything through it and make sure you're not creating some further issue for yourself. Oh yeah, sorry. This is why I'm a law clerk and not a technology person, right? Well, he's like, she's never going to get my job. Okay, and in Chapter 13 cases, with our new plan, we have, and with our new amended national bankruptcy rule, we have the ability to avoid judicial liens through the Chapter 13 plan. So, standalone motions to avoid judicial liens in a Chapter 13 are not necessary, and please don't file them. You probably will get an order denying it because it's not necessary if you do. So, and of course, that's found in Section 3.4 of our new form plan. We call them embedded motions, but Judge Bonifel doesn't like the term embedded motions, so we'll just call it Section 3.4 avoidance. John, did you have anything to add about the process of the new plan? Or
no, I mean, I think we'll cover some of that a little bit later.
We're coming up to more detail on that in a minute. So what liens are avoidable? Judicial liens. There's a definition in the Bankruptcy Code that tells you what a judicial lien is. It's a lien obtained by judgment. Very descriptive. It's not a tax lien because a tax lien arises by statute. It's not a mechanics lien that would otherwise arise by statute. So if you have a question about whether or not this lien can be avoided, maybe it's a homeowners association that obtained the lien, and although in part it might be a judicial lien, the part you're really trying to get rid of is probably a statutory lien. So think about before you file your motion or put it in your plan whether or not it's really a judicial lien. It also doesn't allow you to avoid a judicial lien if it's for domestic support, something I hadn't really focused on in the past, but this is a good reminder of that. Non-possessory, non-purchase money security interest in household goods, we usually say that, but in fact it's more than just household goods. There's a whole list of things that it could also be in, but generally I think those would be subsumed within the category of household goods. But there is a definition of household goods in Section 522F4. If you've never read it before, you might want to check it out because it's strangely specific about how many TVs you can have and whether or not, I know Judge Bonifaz always thinks it's odd that it includes VCRs, but there's no mention of DVD players. So we're not sure what to do with those yet. John, I think you have a war story about 522F4.
So obviously OCGA comes into play here as well, and I'm not going to bog us down in discussion about that. It's not quite as restrictive as 522F, but I think that the courts have sort of applied them similarly. But if you're looking at 522F, I once had a case several years ago at this point, and I don't see Paul Knight, he called me out on this. But we were taking federal exemptions in that case, and it was an NPMSI motion to avoid lien, and my client had pledged 3 TVs, 3 flat screens. Plasma's back then. Plasma's gone out of vogue now, but there's 3 plasma screens. And Paul came in and said, you know, I'm not going to file a response to this, but this is inappropriate because of, you know, you only get 1 TV under 522 F4. And I went back and I said, well, you guys, we didn't have the entire contract. I said, can you send me a copy of the contract? And sure enough, there it was. 3 plasma TVs, a VCR, a lawnmower, and right there, we weren't able to exempt all 3 TVs. At the time, we ended up just withdrawing that motion and treating it in the plan, which worked out okay because we just did a cram down, which taught me something new back then as well, which I'll cover in a little bit. But it's good to be aware of what your debtors, as debtors counsel, have pledged as collateral. It does matter. The code is specific about certain things. You can't just lump it all in as a household good and say it's all exempt because I have enough exemptions. There are specifics that may pull it out of those exemptions, and that could be, could mess up your case potentially. You know, hopefully it's not enough of an NPMSI to do that, but be mindful of that.
Anything you want to add about?
No, I think so.
I wanted to catch one thing, kind of the gap in between judicial and statutory liens. There can be crossover there, obviously. The IRS has a statutory lien, and an HOA has a statutory lien, and a mechanic's lien is statutory, and they're required to get a judgment lien to perfect it within a certain amount of time. Avoiding the judicial lien on those does not make the statutory lien avoided. The statutory lien will still stand, regardless of if you've avoided the judicial lien, which came after the fact. So just wanted to make sure that to point out that there is some crossover there, and you have to be kind of alert for that.
Okay.
There we go.
Okay. All right, so in order to determine whether or not the lien is avoidable, just some really basic fundamentals. First of all, you establish the debtor owned an interest in the property at the time the judicial lien or NPMSI attached and on the petition date. Secondly, you do have to establish that the debtor is entitled to an exemption. And generally, we're talking about the exemptions that are permissible under Georgia law, because most of the time our debtors have lived in Georgia long enough to have that. But if you have a client that obviously just moved here, you might want to look into whether or not they're entitled to another state's exemption or federal exemption. The debtor doesn't need to show that she has equity in the property because the statute says you're working with the exemption that the debtor would have been entitled to. So that's code for just because there's no exemption and the debtor, or no equity doesn't mean the debtor isn't entitled to an exemption. And I've never been 100% clear under the law whether or not if your debtor doesn't list it on Schedule C and claim the exemption, whether they would still be able to avoid the lien. But I think just to avoid any questions that may come up in the future about whether you successfully avoided a lien on a particular piece of property, it's best to just claim all the exemptions you can and avoid any questions about whether or not you've avoided it and whether or not there's been proper notice to the holder of the lien with regard to that piece of property. Anything to add to that, John?
No, claim the exemption if you can. I mean,
yeah. Doesn't hurt anything.
There's a button in there to claim the exemption up to 100% of the allowed legal limit. I mean, if you've got a question, just click it. It's not going to hurt you, and it's going to make sure you cover that if you get an aggressive opposing party that wants to say no exemptions will claim, that sort of thing.
So now we have, back to our statute, 522F, that tells us that a lien shall be considered to impair an exemption to the extent that the sum of the lien, all other liens on the property, and the amount of the exemption the debtor could claim exceeds the value that the debtor's interest in the property would have in the absence of any liens. I have an example here, very basic, fundamental, about how the math works. And I've been told that lawyers don't like math and that I shouldn't get bogged down on this. But if you want to come back later to review this, it's in the presentation slides. And, of course, another plug for use the lien avoidance calculator on the course website to do this, because it will help you figure out if you have some issues, especially of the kind that we're talking about coming up. And this is my big plug for lien avoidance tools. It shows you where to find them on the website. So under attorney information, motion to avoid lien tools, we have how to figure out whether a lien impairs an exemption and the lien avoidance calculator. All, I think, courtesy of Judge Massey. All right, so some of the issues that we come across when we get a motion to avoid lien and it's given to the law clerk to review is that what if the debtors own the property jointly and only one spouse is on the judicial lien, is only named in the judicial lien? So we call that fractional interest in the property, and the majority view is that you base your calculations on only the debtor who is the debtor in your case. So you divide everything by half, basically. So if we have a fractional ownership interest, we divide the amount of the amount of the value of the house by half after we've taken away the liens that are owed by both owners. So, for example, if John and I own a house together and we're both liable on the first mortgage and all other liens, we'd start with the full value of the house, take away all the other liens, and then if I'm the only debtor, I can only use my exemption and I can only use the judgment, we'd only use the judgment lien if I'm the only one on the lien. Everything to add to that? Oops, that's backwards. Okay. Again, the lien avoidance calculator accommodates fractional spouses owning the property, and it also accommodates multiple judicial liens. So if you have a debtor who has 3 or 4 judicial liens on all of the property, you can use the lien calculator to work through them all. So when you have multiple judicial liens, you have to avoid them one at a time. That's a common problem that I see, especially now with the Chapter 13 plan form. There's no instructions on the form as to use 2 boxes or what order do I start in when I'm avoiding the liens. But basically, you would start with the judicial lien that would have the lowest priority under applicable non-bankruptcy law. And this took me some figuring out when I had the first issue, but in Georgia, the oldest judicial lien has the highest priority. And then when you think, okay, well, these 3 liens were all entered in 2018, how do I decide which one is older? All judgments rendered at the same term of court are considered to be of equal date. So if you have liens that are all entered in one term of court, still not exactly sure what a term of court is, but there's that issue to work through. So once we've avoided the most recent judicial lien, then we do the next one. And when we do the next one, we don't take into account the one we've already avoided. So you can't double count. If you've already avoided one, you have to leave that one out. We had this issue come up once in a case, actually pretty recently, that there was an unavoidable lien that was lower priority than the lien that was avoided. And the creditor wanted to argue that, well, I'm higher priority than this lien down here that can't be avoided because it was a consensual security interest. So the creditor wanted to take into account the fact that it was prior to the judicial lien, and you can't do that. It's, you have to include all liens on the property that are not avoidable. And there's an 11th Circuit case that says that. So have you ever had that issue come up?
I haven't had it come up, not under the new plan anyway. I mean, under the old plan, we just filed all our motions to avoid lien at the same time, and we got orders. It's pretty simple. But in doing this new map, you kind of have to start with the newest first and work your way down through the plan. And like you said, account for whatever you thought that lien was impairing the exemption. You can't account for that when you get to the second and or third. You know, if you've got 3 judicial liens, essentially, where I'm going at, you get rid of the first one, newest one first, stop accounting for that one for the second, get rid of that, stop accounting for that one for the oldest.
I should just put that on the slide.
Yeah.
That's actually,
just kind of walk it down through the plan sections and do it that way, and you should be able to properly account for it if you do it like that.
And that is one of the common mistakes that we do see when reviewing plans, that if there are multiple liens that are being avoided, that is a very common mistake, that you don't account for the same, for that other lien. So those lines within the Section 3.4 that you're completing, if you have multiple liens, those numbers are not going to be exactly the same on each line. You'll have to account for that prior lien that you've already avoided when you're going on to the next one. So that is one of the common mistakes.
And that will stand right out to you when you see 2 boxes avoiding the liens and the numbers are identical, or other liens, because as you move down the list, other lien numbers should change and get smaller and smaller. All right.
And that kind of leads into, I'm going to kind of transition into a couple things that are other common mistakes that at least our office sees or I see when I'm holding meetings with creditors and reviewing plans. One is very simple, just leaving an entire line blank, like the exemptions. You'd be surprised. It seems very intuitive that you would want to complete each of the lines, but very often we see a blank line, and that's automatically going to make our office take a second look at it and say, well, should that be blank? What should be there? Like, for example, exemptions. Just about everyone takes an exemption of some sort, at least one, even if it's just over your household goods. So there generally is something there. Other common mistakes are, take a look at your schedules and what you're completing in the plan. A lot of times those numbers aren't matching up. So just be conscious of, like, if you took a certain number of exemptions that apply to the collateral that you're avoiding, take a look and make sure that those numbers are the same, that you're matching up. And just, as John said earlier, just take the 5 extra minutes to check your math, check your numbers, because that's something that we
use the lien avoidance calculator.
And use the lien avoidance calculator. And probably one of the biggest issues that we see is what we have here on the screen for multiple.
We're not quite there. Okay, here it is.
Multiple properties.
We call this lumping.
So sort of the lumping issue, meaning you have maybe a non-purchase money security interest in household goods, or all real and personal property for a judicial lien, or perhaps it's that TV, the VCR, and the 1993 Walkman that they pledged back in the day that obviously they no longer have. So we have a lot of, those are very common. We see those very often. But what people tend to do is they want to put all of those collateral, we'll use the easiest one, all real and personal property. So that's basically everything you're going to have on there. They want to put everything in there at once. We can go back one slide. I'm going to kind of walk through the one example that we have, and unlike the other example, they did not give me nice, even, round numbers. They gave me the more realistic numbers that you're going to see when your clients come in.
And this is actually from a case that I had, so that's why the numbers are. So they're, you know, names are omitted to protect the innocent.
So you don't get the even 200,000s with 100 owed. You get the 206,400. I'm going to do the math for you, so don't worry. But when you're looking at the house, so you start with what you want to do. The way to do this is to look at each item individually. You want to look at each asset that the debtor has. So in this particular case, you have the house. You walk through it. You take out. You look at how much the fair market value is. You take out the mortgage that's owed. You take a look at the exemption and subtract that out. When you do the math, in this particular circumstance, the equity in the real property is $31,684. Going to the next asset, there's two different cars in this case. One car has negative equity of $14,842. See that all the time, cars that are underwater. And then the other car, maybe they own that one free and clear. That's their, 1991 Ford Taurus that's sitting in the garage that doesn't operate. But
how did you know that's my car?
And then, the household goods, and then it looks like in this particular case, there's also financed furniture. So it looks like it's being valued at $500, but they owe $2,422. So again, it's a piece of property with a negative equity in it of $1,922. Yeah, and then go to the next slide. So once we if you take a look at that whole case, if you lump it together and do it the wrong way, you're going to end up with $26,865 if you use the negative equity from the car and the negative equity from the furniture. If you lump all of that together, it's going to give you a $26,000 number. But if you take each asset individually, you're going to see that the house, going back to our fund math, was a little bit over $31,000, so $31,684. Negative equity in a car, which is should not go against, it won't take away from the equity that's in the house. So when you're,
because it's not an all other lien on the property when you treat each property separately.
Correct, exactly. So when you're looking at this, the correct answer in this particular circumstance, when you separate out each asset, is that the $39,000 lien that was the premise in this case is secured up to $31,000, not the $26,000 if you add it all up together and with the pluses and minuses. Something, a very good practicing point for everyone who does this, take a look at what exactly your collateral is and then go through item by item if you have multiple things, particularly if there is one asset that you can kind of look ahead of time and there's equity in it. Double check your math and look at each item one by one.
And you might actually have to do a separate box for real property and a separate box for personal property if you have a situation after you've used the lien avoidance calculator and identified your problems, then you might separate them out into two different boxes. And I assume there's a way to do that with the software and stuff. But I've never had to do that myself, so.
I'm sure that there is.
The next slide actually has an example of how this would look when you plug this in. And I don't know that you necessarily have to use a separate box, but again, just in that collateral section, just be specific as to what you're looking at. For the most part, I think people are pretty, if it says all real and personal property, you'll figure out where the equity is. But there's the right way and the wrong way, so just make sure you're paying attention to what assets have collateral and don't lump them all together.
And so you'll see the only difference here is the number on the right way is bigger than the number on the left. But in real life, this turned out to be not avoidable at all because the debtors were wrong about the value of the house and had to amend it. And so eventually this plan provision disappeared altogether, and they dealt with the lien in the section where you would pay in full a claim. Okay, John.
All right, so we wanted to take a minute just to kind of discuss those situations where avoiding the lien, you know, it may come across your desk and you're not sure whether it's worth it to file it in a Chapter 7 situation to file a motion, or in a Chapter 13 situation to deal with that new complicated, but maybe not as complicated as you think, plan section. And there were a couple things that came to mind when I was kind of going through that. Where is the property? Well, we're filing here, obviously. So is the property? Getting myself backwards here. I'm putting the cart before the horse. So where does the debtor own property? Is it located where the lien, the judicial lien, is? More often than not, I have this with out-of-state debtors that have moved to Georgia in the last 2-3 years. They've got a 4-year-old judgment lien from Massachusetts or wherever, and that has not been domesticated. Make sure it hasn't been domesticated. You know, GSTCCA will have that if it's there. But if it's never been domesticated, that judicial lien is only valid against property where the judicial lien is. If they don't have any property in that location, then it's probably not worth it to file a motion to avoid judicial lien, and I generally am going to list that as a Schedule F general unsecured debt at that point. There may be a piece of paper somewhere that says there's a judicial lien, but if it's not secured to anything, it's not secured. So you can kind of, you know, get those out of your way right there. Another one is when we're looking at the NPMSI stuff, do they still have that collateral? And, you know, there's been some debate over whether that matters, but I think it matters a great deal. If they don't have the collateral that secures that lien, then there's nothing to avoid. You know, they have a claim, it's probably a valid claim, but it's now unsecured because there's no collateral for them to attach it to. So in that instance, I don't think avoiding the lien would be worth it either, and likely would list that in Schedule F as well. Think World Finance, First Franklin, these types of places. You know, yeah, I pledged my TV and VCR 5 years ago. I don't have that TV and VCR anymore. That's been gone. I left it with my old boyfriend, or it stopped working and it hit the curb, whatever. You know, you could end up in a evidentiary situation with that if you've got a creditor who says, you know, prove it, essentially. I think it would probably be on the debtor to have to prove that they no longer have the collateral as opposed to just coming in and saying I don't have it. You know, they may have to take the stand under oath and do something like that. But let the creditor bring that. As debtors counsel, I would advise put that burden on them. Put it in Schedule F and don't worry about the lien. And if we're looking at a Chapter 13 case, and both of those apply both in Chapter 7 and 13, what I just went over. The next part is in a Chapter 13 case. If you're looking at a non-purchase money security interest loan and it's more than a year old, the code allows you to cram that down anyway. Take a look at what was pledged and, you know, do your best guess with your debtor to try and figure out how much is this thing actually worth. You know, you can buy a really nice TV today for $1,000. 2 years from now, that thing's going to be worth $150 because, you know, technology has moved past it in light speed. And you can just cram that thing down for $150, you know, pay that lien under the cram down section as opposed to avoiding it, and do it that way. And last but not least, if you're not sure what to do with it, file the motion. Put it in the plan, avoid the lien. You know, I don't do that, obviously, in the situations that I listed, but if you're ever sitting there and it's a gray area for you, just go ahead and take the extra time and do the motion, because then you're going to have some peace of mind with it, and your debtor will as well. Moving forward, you don't have to worry about, you know, what if I don't avoid this lien and my client moves back to Hall County where he didn't have property when I filed this case, but now he's moved back. I didn't avoid this lien, stayed valid on, you know, with the county, and now I've set my client up for failure there. So it's one of those things, when you have a gray area like that, go ahead and file it. But otherwise, in those other situations, I don't think you need a motion or to treat it in the plan in the, you know, motion avoidance. You can kind of save the time and effort. As we're about to talk about, the service on these things can be very frustrating. And if you don't have to spend half an hour and a half researching who the Secretary of State's got on hand and who's the officer, who was the officer, all of that stuff, if you can avoid that, I'd say take the opportunity.
Another little practice point to kind of piggyback is pay attention in a Chapter 13 case, pay attention to the claims as they come in. You may be anticipating something that's a World Finance and you're anticipating it secured and it comes in unsecured. or vice versa. Maybe you were thinking you scheduled it on F and now they've filed a secured claim. If that's the case, you're likely going to see at least an objection from our office that you haven't treated that now secured claim. But pay attention. Take a look at, especially with the bar date so close in time to confirmation, there's really no reason not to take a look at those claims. And then obviously also with the bar date and creditors, you kind of have to take a look and see, do you want to file a claim on their behalf? I don't know if there would ever be a situation where anyone would want to do that, but that is something with the new bar date that may come into play if it's something that's significant or of importance to your client or the debtor that needs to be avoided.
Yeah.
Great. Okay, I think we thought at this point would be a good time to sort of pause and see if anyone has any burning question or helpful comment that they think would add to any of those topics.
Keep in mind we're about to move into service here,
yeah.
So if it's service related, give us a second, but if it's not, shoot.
We kind of talked about what it is about 7 well that one of the members well, a while ago you do most of the delivery in the time. Well, we are but now that it's part of the new plan, what do you do in motion or what
My vote would be based on the Harris decision. Once it's converted, that plan is.
You're talking about conversion 13 to 7 or 7 to 13 or either? 13 to 7.
So my inclination would be that probably best practice would be to cover your bases and do it again, but ultimately I think that's going to be a judge's decision.
Yeah, I haven't seen that come up yet specifically, so I don't have a rock solid answer. We have a couple judges here who may want to chime in on that, or they may just want to eat their lunch back there.
Any guidance there, Judge?
You want me to activate bar end so that they can access bar end? Okay.
I would say probably, like Julie said, your best practice is going to be to go ahead and file that and get a new order. But this is one of those situations where think about your case progress from the beginning of it. When you first have your client, if you know that there's a chance of a conversion, there's somebody that's filed a stop foreclosure, they're going to work on a loan mod, and when they get that done, we're going to convert this case. There is a process to get an order on the docket following plan confirmation that specifically outlines that this judicial lien has been avoided by itself. I think that would stand alone in a conversion, even if argumentatively the plan confirmation order no longer is valid in a conversion. That might be a situation where you just want to pay attention to what your client may expect in the coming months and years of the case and take that extra step to get that specific order on the docket. And I think that would still stand without having to file a new motion.
Okay, any other questions? Yes.
I'm not sure whether the plan is not confirmed, you don't believe it's not.
Right.
Correct.
So if the conversion occurs for confirmation, it's a problem.
Right.
Right.
Yes.
And we do have a slide at the end that talks about amended Rule 5009 of such an order, but it doesn't really give any guidance about when you're supposed to. Right.
Yeah.
So stay tuned for further developments. Anything else? Questions? Yes, ma'am.
So, also, if there's no property in the water, just for the
Mm-hmm.
is that
it's not necessary, I don't think. That's the way the code sets it out, but it's not unnecessary. Like I said earlier, if you use the software, I said you can click a button. If you're filling it out paper form, you can check the box. It says take up to the 100% allowable exemption. Sort of the same thing that you're doing there. You're putting $1 in so that you can apply the exemption so that it's now on the schedule. Right.
But one, I would caution on using the 100% across the board because you'll see an objection about that because we want to know that you're not exceeding that. So we don't know to what extent you're taking that exemption. what you're 100%, it raises questions. So we would err on the side of we want you to use specific numbers in those exemptions so that we know what you're claiming, so that the creditors know what you're claiming. And what that $1 comes into play is there's some, I don't recall the case name, but there was a case, and I believe it was even in the Northern District, where it was that was intended to be representative of the full amount of any, so $1 intended to be representative of any equity going forward, and I think that it caused trouble in a case going forward. So that's why our office triggers in our office. Is there really $1 in that account, and you're just exempting the $1, or are you trying to make the $1 be representative of the entirety of the entire account, and you don't have the full number there? So just be careful, be cautious. Best practice for at least our office is to claim your specific exemption in the amount that you feel you are eligible for, to which you would be entitled.
Correct. I was going to say, my office would argue otherwise.
Explain why.
Well, sure. I'd be happy. You're going to know it better than I, but particularly I've seen that come up when we're dealing with insurance proceeds. If a debtor has a casualty claim or something like that, and we have limited it to $500 because the trustee wanted it specific. If, the insurance really needs to be more than that. Res judicata can come in there on a confirmed plan specifically. And the insurance company may cut them a $500 check for what might be $4 or $5 grand worth of furniture, or anything like that. A life insurance policy could be an issue, something like that. That's where I see an issue with it, and that's where I would push back on the trustees with specificity, is that we've got debtors kind of guessing a little bit on the fly what is my stuff worth, and if we tie them down to a low number that may not quite represent everything, they may be locked into that and really be in trouble. I don't know if that addresses what you were thinking.
Beyond that question, post-petition appreciation is the case.
He's done.
We have a property that's worth $1,000, mortgage is $80 on the data file, $20,000. Go through the case 2 or 3 years. 1977 is worth $160,000. If you claim $20,000, trustees can sell that property for $150,000.
Right.
Claim 100% of the exemption of fair market value. It's arguable. This is still in dispute. It's arguable when you exempted the house. So the trustees not this close to That's why we. That's why.
Yeah, exactly.
That's why the trustees always object to this. And but that's the issue. And be aware that that's the issue. That's the result.
And I believe there's a big discussion of that in the Chapter 13 book. Am I right? If anyone's interested, you can check it out. We have a question from a listener. I'm not sure if you want to cover that. Does anyone have thoughts about the ability of a judgment lien holder having an ability to refile the lien to re-perfect following discharge to continue its lien on the ride-through theory at the end of the 7 years? Assuming she's talking about a lien that's been avoided, I don't see how you would be able to refile a lien that's oh, that hasn't been.
I think that's,
yeah. Oh, yeah.
I think that absolutely could
That's
be.
why you would want to avoid it, right?
After acquired property in that county or state, I think it would be a strong argument, if not an absolute argument, that could perfect that.
I'm not sure I heard all that. Cannot apply post-petition process. Judgment lien system cannot apply.
Following discharge?
Following discharge. It may still be a thing out there. It may be a title problem if you want to sell or refinance the property. Matter of law, I don't think that doesn't mean.
Because the debt's been discharged.
Avoid termination, better liability, and cannot attack.
There you go, Sheena. She didn't even have to file a motion to find out the answer. All right.
I still file a motion to get rid of it.
Absolutely.
Right, yeah.
if that judge's creditor has a different view, you have to go to court.
All right, so we have a few minutes. We'll talk really fast about service, unless you want to take questions now. Okay. So, serving the plan. Julie, do you want to cover sort of our new regime on service?
Can I, please?
I know you deal with everyone every day, all day.
Everyone loves this. Trustees, debtors, attorneys, creditors, everyone. Made everyone's life good. But quick, the abridged version of this, if you are avoiding a lien, which should be included in the Chapter 13 plan, and it should be in Section 3.4. If there's something in Section 3.4 that you're avoiding that requires that you're going to follow 7004 service, you're going to be serving the registered agent, the officer. Pay attention to whether what you're avoiding is an FDIC. All of those things are going to come into play. Again, there is, again, we'll plug, because I know we're running short on time, but plug the resources on the court's website that help with this service. But as far as our office, and I know there's some differences between the three trustees' offices and even the judges on what the expectations are for review, but for our office, we're wanting to make sure, if we see a provision within 3.2 or 3.4, we're looking that you did, you served the plan on all creditors, and then you did a certificate of manner of service for those creditors that need 7004 service.
Right. So if you would have served it in a specific way when you filed a motion in a Chapter 13, file it the same way, file your plan and your notice of confirmation hearing the same way you would have filed your motion, and file your CMOS. Any questions about that? We have a lot of slides about 7004 service. We won't have time to get to them all, but they are in the presentation materials. They are based largely on Judge Massey's monograph on service, again, available on the website. Some of the sort of issues that I come across on a fairly regular basis are when you serve an FDIC-insured depository institution and you serve the registered agent, it's not ever going to work, even if you serve them by certified mail. You have to serve an officer by certified mail. You cannot serve the registered agent. And you can serve an attorney who has filed an appearance in the case. But most of us, I think, interpret that to mean they have filed a notice of appearance or something in the bankruptcy case. That also leads me to my other regular issue, attorneys who are served, because they're the ones who got the judgment. We don't have any way of knowing if they still represent that creditor 5 years later, 4 years later. Sometimes the law firm that you serve isn't even in business anymore. So if you're serving just an attorney, you might want to dig a little deeper and find an officer or registered agent for that creditor. And then my final sort of pet peeve is that when you have a judgment lien that was obtained by an apartment, the apartment itself isn't the respondent. You cannot serve Oaks at 3 corners because it's an apartment building. It doesn't own anything. So you really need to look to see who owns the apartment building and then serve somebody who is authorized to accept service of process for that company. Yes, ma'am. That's true. Right. And I think maybe John could address that in terms of when do you decide that there is or isn't a lien to avoid?
I mean, in that situation, that's one where I'm going to be always overly cautious. I'm going to find out who the management company is, and I'm going to file it against the judgment holder, and I'm going to serve it on the management company.
Or maybe name all of the entities. I don't know whether or not
you can name them both, you know, the Oaks at whatever you said, and so-and-so as management company. It's covered both.
You're talking about for service or for receiving and the response?
Both.
Both. I think it's careful to have both. I've had many motions to avoid lien, particularly when we had to file the motions and everything, where you don't have each name listed on Schedule D. It gets kicked back to you because they're not in the schedule. So I think you list both. So that's one of the things you got to do right up front with your intake is figure out who holds that judgment.
It's like you said, it makes it really hard when the judgment itself is in the name of some entity that doesn't exist or couldn't exist.
It makes it hard, but it also has this piece of paper saying we have a right to select.
Right. And you're just trying to clean the record up.
But the owner does. The owner of the apartment complex doesn't have such a piece of paper.
Right.
I say overdo it and get your judgment lien and serve it on that owner and just make sure everybody's covered.
Do we have any other quick service questions? Because we have about 2 minutes left. Yes, ma'am.
All I did was, I put you at that point when Thursday turned into a file that was one of those things.
Right.
Listed, they're no longer active.
What do you do in that situation?
Yeah, that's exactly where I was going to go. All I've done there is, what was that you said?
Under state law, you can serve the Secretary of State.
Yeah, there's some extra special rules on that, but that is one possibility. But what I typically do, which is, I believe Judge Bonifeld might have said it there, I didn't quite catch who it came from. The Secretary of State's usually still going to have officers and things like that listed, even in a dissolved company. I'm going to serve those. I'm going to serve them at their old business address. I'm going to serve the officers. I'm going to serve the attorney that had the judgment, even though they haven't appeared in this case. I'm not using them to perfect my service. I'm going to hit all of those people, and if I get an order, I think it would be effective.
You have to worry about it because the corporation can reinstate.
Absolutely. Yes, they can cut. Yeah, just because they're dissolved now doesn't mean they won't be next year.
Any other questions?
All right.
All right.
I think we're out of time. Thank you, guys.
Exactly 12:45.
Thank you all very much for coming in for our panelists for that highly informative presentation. Again, please be sure to review the materials, and thank you all for coming. And if you would like daily credit, please be sure to see Gail up here, and you all take care of that. So